city continue to push for some kind of penalty?
Well, if a person received a citation, so if they did, then they would have a defense of necessity. It's asserted as a defense. So what the other side is
Well, it's asserted as a defense.
Yes.
I mean, so you're not willing to say, no, we're going to tell all our police officers that they shouldn't give a citation in that circumstance. You know, we're going to give a citation and then we'll see how the courts deal with it, is all you're going to tell me.
Officers always have discretion, and we know that they exercise it, and it's hard to know.
The question is not an individual officer's discretion. Individual officers are in a tough situation here.
They are.
The question is, what is the city going to tell individual officers? So what is the city going to tell individual officers about a case of the kind that I said? Are you going to tell individual officers, issue the citation and we'll see if the person knows enough to make a necessity defense and we'll see what the court does about that? Or are you going to say, you know, there are some things that just ought not to be the subject of civil or criminal infractions?
So the city, in its policy, at a joint appendix, page 158, for example, talks about what officers are supposed to do. They're supposed to put people in touch with services first, to contact if there is available help for them. These laws are absolutely a tool for getting people the services that they need. Many people need that intervention.
Well, you're not giving me a real answer
Yes.
to the question of, is the city telling officers that they should give citations in that circumstance?
No, it is if somebody, again, it is a matter of discretion.
Is there anything you can point? It's a matter of discretion.
Yes.
There's nothing you can point to that the city says, we have a necessity defense. What we're telling officers to do is to, act consistently with that defense, so that if it is truly a matter of need, that you are sleeping on the street alone with a blanket, no, the officer should not cite the person.
There's nothing in the record here that shows officers were told about a necessity defense and that what it would or would not preclude. That would be an individualized question after the fact if someone received a citation. And if they thought that that wasn't enough, the proper framework would be this court's framework in Kaler, where we would look at the asserted defense, their insanity of some form, and here it would be necessity, and we would ask whether it is so deeply rooted in our history and something that has to be imposed in this way on the states.
Thank you.
Thank you.
Justice Gorsuch?
I suppose someone could also initiate a class action of the sort that happened here if you were not allowing the necessity defense to operate and seek to have it enforced, couldn't they?
Potentially.
Yeah, thank you.
Justice Kavanaugh?
You've said several times that it's a difficult policy question, a complicated policy question. I think everyone would agree with that. How does this law help deal with the complicated policy issues?
One of the most difficult challenges is getting people the help that they need. And laws like this allow cities to intervene, and they are an important tool in helping incentivize people to accept shelter. So Ms. Johnson, for example, has said in her deposition, it's in the joint appendix, that she does not wish to stay at the Gospel Rescue Mission. One of the reasons is because of her dog. She also had other reasons. She doesn't like being around people and so forth. People have all sorts of circumstances. It's very complex, and the individual
How does it help
decisions.
if they're not? How does it help the rule here, the law here? How does it help if there are not enough beds for the number of homeless people in the jurisdiction?
So for Ms. Johnson, she sometimes stays with a friend. So there are other.
More generally, though,
Yes.
I guess if there's a mismatch between the number of beds available in shelters, even including Gospel Rescue, and the number of homeless people, there are going to be a certain number of people who there's nowhere to go.
That is a difficult policy question. And
how does this law
Yes.
help with that policy?
So it encourages people to accept alternatives when they come up so that fewer people end up camping. It also there is harm in simply camping. Whatever materials people are using when they are living in public spaces without plumbing and infrastructure, there's harm to the whole city and to the whole community as well as to them. We know that encampments and these conditions also breed crime and very dangerous conditions. So the city has an interest in protecting everyone,
Do
including...
you think the constitutional rule should be different when the number of beds available in the jurisdiction exceeds the number of homeless people versus the number of homeless people exceeds the number of beds available in shelters?
No, that's what we've seen in the Ninth Circuit. We've seen that that is unworkable. There is no way to count what beds are available and who is perhaps willing to take one and who would consider it adequate. Then the question becomes, are those beds adequate? So here, Gospel Rescue Mission.
That's a
again,
separate issue, I agree.
It is.
And it can be a challenging issue, I suppose. I know as well. Let me ask one last question, which is how does the necessity defense differ from the constitutional rule? You touched on this, but I just want to get a succinct answer to that. The state law necessity defense differ from the constitutional rule here.
You would weigh the harm from the individual's conduct in violating the law. So if someone were camping near a school or near or doing something or engaged in some behavior that was particularly harmful, and they had another place where they could camp, that would be maybe a factor that you would raise in the necessity situation. It's narrower. So in a case of the Oregon cases include people who are growing marijuana for medical reasons but without a license, and so the necessity defense was not accepted in that case because they could have obtained a license. So if a person had a friend to go to, had a bed available at the Gospel Rescue Mission, they would be expected to take it under the necessity defense. I think that's how it would play out.
I actually have one last question. When you get out of jail, if you end up, what's going to happen then? You still don't have a bed available, so how's this help?
So I do want to make a point about that, about the criminal aspect. The trespass law here is only triggered after several civil citations.
Right. No,
and
if you run through that cycle and you end up in jail for 30 days, then you get out. I mean, you're not going to be any better off than you were before in finding a bed if there aren't, going to my earlier question, if there aren't beds available in the jurisdiction, unless you're removed from the jurisdiction or you decide to leave somehow.
No, there are services available, and the jurisdiction can put you in touch with services and programs to help you in those circumstances. And for many people, that is a point where they're able to get into treatment. So that intervention actually saves lives.
Okay, thank you.
Justice Barrett?
So let me follow up on that. So you're saying there are services available, there's treatment available, so people would ultimately move off the street? Is that what you're saying? Because I think part of the premise of all of this, right, is that there are not enough beds for homeless people to occupy, and so there will be a mismatch, and there are going to be some people who can't be cared for.
Oh, I'm saying that's a policy question that is quite difficult, but these laws are an important part of the puzzle. They're not the only solution, and we don't believe that they are, but we think they're an important tool. And without them, we've seen what's happened on our streets. We've seen that people are dying in encampments. We've seen that cities are being forced to cede all of their public spaces. So that ultimate question is for the legislature and policymakers to figure out what the right solution, what the right mix of policies is. But the wrong answer is to do what the Ninth Circuit did here and to constitute.
Let me just interrupt you there. You're right, it's a very, very difficult policy question. And I asked you before about whether this was just about blankets or whether it went into having fires or urinating and defecating outdoors and that sort of thing. And Justice Sotomayor pointed out that this particular injunction did carve out those things and was just talking about sleep. But, you know, other cases have been litigated in the Ninth Circuit that have gone beyond that. And because the line is things that are involuntary, that are human needs, it can extend. It's difficult to draw the line. And whatever we decide here about this case is about the line. So can you describe for me some of the things that are difficult to figure out about the line? They're sleeping with blankets. What else?
Public urination and defecation, that is a serious problem. Those are parts of biological necessities of being human. A court in Sacramento addressed that, and the Ninth Circuit's opinions debated whether its rule would actually reach those things. I think any rule that we are wondering about and debating whether it would go that far, I think that is a sign that it is not a workable rule. The slippery slope here is very real. It's not just for camping and conduct that might be a biological necessity, putting aside tents and fires in cold climates. What other things would be allowed? All of the things that a human needs to survive, for example, potentially come into focus under the Ninth Circuit's rule, but also in other areas. Someone could say that my drug use or possession is the other side of the coin because I'm an addict, or because a person who violates other laws could say that I had a compulsion to do those things that I couldn't control. And the plurality opinion in Powell addressed that very thing and why it's so important to draw the line there. And when conduct is involved, and once the court gets into deciding which conduct may be excused under the Eighth Amendment, it is so far afield of what the Eighth Amendment was ever understood to address.
Okay, speaking of status and conduct, you've argued that Robinson was wrong and we don't need to overrule it, and I agree. I don't think we should overrule Robinson. You've also been kind of resisting the status, you've been resisting characterizing anything other than the drug addiction that was at issue in Robinson as status. So what if the law said it is unlawful and punishable by 30 days in prison to have the status of homelessness? Just go with me. Just assume that the law defines homelessness as a status and it is a status. Would Robinson say that that law is unconstitutional under the Eighth Amendment? Would you concede that?
And you're saying that that is a status?
Yes, the law defines
all
it
of
as a
the-
status, and it's a status.
Well, yes, and I think it looks a lot like Robinson under that hypothetical, but of course, we disagree that it is.
I understand you disagree, but you
status
are
in that
accepting
way.
that Robinson draws a distinction between status and conduct, and you're just fighting about the definition of a status?
It draws the line where a law has no actus reus, so I think that's the easiest line. I don't defend the line under the Eighth Amendment because I don't think actually that the court, I know the court didn't rely on any Eighth Amendment principles or
But the
history or-
hypothetical I just gave you had no actus reus either. The status of homelessness. I mean, it could be, 4 o'clock in the afternoon and the person is just standing outside the bus stop. Do you agree that if the law prohibited that, made that a crime, that under Robinson, whether Robinson was right or wrong, that under Robinson that would be a violation of the Eighth Amendment?
Well, I think the better framework is due process.
I understand that. Under Robinson, do you agree that that would be wrong?
Yes.
Okay, thank you.
Justice Jackson?
So, picking up where Justice Barrett left off, you say that the ordinance here pertains to conduct and not to status, and I'm just trying to figure that out. I'm not so sure for this reason. It's because all humans engage in the act in question, sleeping. And yet, the statute operates, or the ordinance operates, to penalize only certain individuals, those who have no choice but to do that act in public. So it appears, I think, not to be the act that the state, or the city in this case, finds criminally culpable. It's instead the act as engaged in by certain people, by people who cannot afford housing and have nowhere else to go. So why is that the wrong way to think about it? And if that is the right way to think about it, why isn't that a status crime in the way that Robinson contemplates?
It's not, because we can look at the law and it has a conduct element. The conduct is establishing a place, a campsite. And that is something that a person who has a home or a shelter
But you've just
could do as
defined
well.
away the basic actus reus, right? The actus reus is sleeping outside, I guess outside, to the extent you put outside in it, but that's the problem I'm talking about. The actus reus is the sleeping, right? Everybody, that's not a criminally culpable kind of activity. That's what I think might distinguish it from Robinson and make it worse for you in a way. Because in Robinson, at least, to the extent someone had a disease, and the question was, well, are they engaging in otherwise criminally culpable conduct, buying and selling drugs, taking drugs? We look at that kind of category of things. Here, the actus reus is sleeping, human, universal. The city adds, okay, but you can't sleep outside. And I guess what I'm trying to understand is, to the extent that that only happens with respect to a certain category of people who have no other place to go, why isn't that really just punishing the status of being someone who doesn't have any place to go?
It doesn't apply only to those people. The respondents here are trying to exempt a whole category of people. So what you look at there is the conduct of camping under federal law, and in this court's decision in Clark, it was understood that that is conduct. It is just like trespass, where if you are found in a place, if you enter with permission, but then you remain there without permission under quarrels.
But it's not just like trespass, because presumably you have other places to go. So let me just ask you this other question. What is your understanding of the Martin rule? Because I thought it was premised on the circumstance in which someone had nowhere else to go and they needed to sleep and they needed to be there, but you seem to suggest that necessity is not sort of baked into what Martin was doing.
Martin speaks in terms of someone who is involuntarily homeless, and that raises all of those policy questions that we've been discussing about how to determine that.
But assume they exist. Involuntarily homeless means the person has nowhere else to sleep.
Yes, that is, the necessity defense is available, and what respondents are asking to do is to constitutionalize that very defense under the Eighth Amendment. So as I said earlier, it could be, the argument could be made, it would be a very high bar under due process, but that is the sort of argument that we would expect one to make under a due process framework under this court's Kaler decision.
Thank you, counsel. Mr. Kneedler?
Mr. Chief Justice, and may it please the court. In Robinson, this court held that the government cannot criminalize status, and respondent has conceded here today that the city cannot criminalize the status of being homeless. Our narrow submission in this case is that government cannot circumvent the principle of Robinson by making it unlawful for a person to reside in the jurisdiction if he has that status. That is what the ordinances here do. As applied to someone who has nowhere else to sleep, which is an essential human function, the ordinances are the equivalent of making it a crime to be homeless while living in Grants Pass. Although we think the Ninth Circuit was right to recognize that the core principle of Robinson is implicated in this case, the court was wrong to award broad injunctive relief in the circumstances and manner in which it did. The Robinson principle requires an individualized determination, and the Ninth Circuit's failure to require such a determination and its issuance of much broader injunctive relief has led to the problems at issue that the petitioner and its amici have raised, not the core principle of Robinson. And therefore, we urge the court to adhere to the core principle of Robinson, but to emphasize that cities have flexibility to implement these, and in particular, time, place, and manner restrictions on where someone can sleep are entirely valid if they are reasonable. And indeed, the state law that Justice Jackson referred to establishes a state policy that time, manner, and place restrictions are the way to go if they are reasonable. I welcome the court's questions.
Mr. Kneedler, wouldn't you have a better argument if Robinson involved someone being arrested for using drugs, but then the court said that you were in effect arresting him for the status of a drug user because he had no choice but to use drugs because he's an addict? No, our position is not that the conduct, as in Robinson, the drug addict can't stop from using drugs. That is not our position. That's a question of personal culpability on the basis of what. So what's the difference between that and camping out? What you're saying here, it seems as though you're saying, well, there's no other choice, so you have to camp out. Therefore, you're really arresting this person for the status of homelessness. Yes, but not because of an involuntary compulsion sense. I think, as Justice Alito pointed out, the nexus here is actually closer than in the addiction situation, because sleeping outside is essentially the mirror image of the other side of the coin, or the definition of the
is a slippery one, and that they're often closely related. And in Robinson, though, the court said you cannot make the status of being a drug addict a crime, but you can criminalize the conduct, even if it is involuntary and compulsive. And Powell reaffirmed that line very strongly, at least the plurality opinion did, and said we're not going to go further. And I wonder whether the government is asking us to take that step that Powell counseled against by saying that it is status, because effectively status, and this is throughout your brief, you use the word effective or essentially or tantamount to, those kinds of words. And so I just wanted to get your response to that concern.
No, we are not asking the court to take the step that it declined to take in Powell, which had to do with personal responsibility, the sort of issues that were involved in this court's decision.
If you're not asking us to do that, then I guess I just want to circle back to what Justice Thomas was getting at, which is surely the government wants to continue to enforce the drug laws and all kinds of other laws that people could make an argument that I had an involuntary need to do, a necessity defense to. You don't want us to wipe out all of those laws.
Sir, absolutely not. But what is different here is that the conduct that was suggested in Powell would have been based on the person's own separate antisocial conduct.
Well, Justice White made clear that some people are going to be forced to drink in public because they don't have a home. He made this very point.
No, we don't. But the point here, it is the government that is prohibiting the alternative. It's not the individual's inability to control his own conduct. The government, because of other circumstances, the lack of money, the lack of a friend to stay with, the lack of shelter space, there is no place. We take as a given in our position that there is no other place for the person to sleep.
And I think, couldn't a drug addict, though, make the exact same argument? I had no other choice.
But the other choice would be a matter of personal undertaking, personal culpability.
But the record says that there is no other choice. I had to do it.
Well, I do think that in engaging in conduct that is unrelated to, let me take that back. The sleeping outside when you have no other place to go is the definition of homelessness.
Mr. Needler, isn't the response also that those two things are different? I mean, you're sort of saying it's about individual culpability, but it's not as though everyone engages in drug use, right? Certain people do, and maybe they have addiction, and maybe you can't punish them because of the addiction, but you can still punish them as criminally culpable for engaging in the act. It seems to me we are in a totally different category when you're talking about acts that everybody participates in, that no one thinks in and of themselves are criminally culpable, and yet somehow this statute is reaching out to punish certain people who engage in that universal human basic need. That seems to me to be the distinction in these situations.
That is a critical distinction, and not only is it something that everybody engages in, but it's something that everybody has to engage in to be alive. So if you can't sleep, you can't live. And therefore, by prohibiting sleeping, the city is basically saying you cannot live in Grants Pass. It's the equivalent of banishment, which is something that is unknown to the way.
Mr. Needler, wasn't Grant Pass's first attempt policy choice to put homeless people on buses so they would leave the city? And I understood that to be the history of Grant Pass. Police officers would buy them a bus ticket, send them out of the city, but that didn't work because people came back because it had been their home, correct?
They came back.
They came back.
They might have been sent
So then they
back by
passed this law, and didn't the city council president say, our intent is to make it so uncomfortable here that they'll move down the road, meaning out of town, correct?
That statement was made at a public meeting of the city council.
All right, so let's assume what you're saying or accepting, that, do you happen to know, or maybe I hope one of you knows, how many beds there are in Grant Pass, shelter beds?
I believe the only shelter beds, at least at the time the record in this case was compiled, was at the Gospel Mission. Has been at times a detox place. There has been a warming center that has been maintained, but in terms of, excuse me, shelter beds.
Well, we're talking about
Yes, and I think
disproportionate.
it's approximately 100. There's men's,
I thought it was much
women's,
less than
and,
that. Yeah.
Yes.
All right. So we go back to, you want the district court to make individualized findings. You've asked us to vacate and remand. Can we go back to that so I understand it? I quite didn't understand it in your brief, because I thought individualized findings had to do with the class action, but that question hasn't been certified here.
Right, but I think the merits. Our basic point is that a person does not have an Eighth Amendment defense or an Eighth Amendment claim unless he truly does not have some other place to reside. And so, by speaking of individualized, what we were saying is that it depends on whether that person has some other place, has a relative.
I accept all of that. I guess what I'm asking you is, and this is what I didn't understand from your brief. Are you saying that there can't be a class certification of homeless people ever?
No.
That you have to have individuals? Or are you saying that the injunction is too broad if it doesn't provide for remedies that are somehow that the person has to prove a certain number of things before they're entitled to the injunction? I wasn't sure.
No, but the Eighth Amendment claim is a personal one, and this context depends on whether the person does have another place to sleep. So the person cannot benefit from the Eighth Amendment claim without an individualized, without that person showing, if it comes up in a affirmative injunctive action, without that person showing that he or she has no other place to stay.
Thank you, counsel. If there is the town next to Grants Pass, 10 minutes away, has just completed building a homeless shelter that has many vacant beds. Does that change the analysis here? I mean, we've talked about the town wanting to ship people out of the town. Would it be, would there still be a right to sleep contrary to the ordinances in Grants Pass because you don't want to be taken 10 minutes away where there's a homeless shelter?
That goes to the question, I think, of the analysis of whether the beds are available. There's a homeless shelter there, even though it's not one in the city of Grants Pass. But often in a situation, the two towns might cooperate to have one homeless
Well, yeah,
shelter.
they might, but often mixed towns don't always cooperate. So what if it's 30 miles away? Is the shelter available in that case for your purposes? Or are you going to tell me it just depends on all the circumstances?
Well, I think it depends on
so municipalities won't have that much
I think
guidance.
it depends on the accessibility. I mean, one of the fundamental points here.
The accessibility is that when an officer comes up in Grants Pass and finds a homeless person and says it violates our ordinance, but I will give you a ride down the road, 30 miles, whatever it is, because there's a new homeless shelter there. And the person says, no, I don't want to do that. Can that person be given a citation?
I think probably not, but let me, if I could explain why. I mean, obviously there are questions at the margin here, but I think one of the principal features here that shouldn't be overlooked is the city is seeking to banish or expel its own residents, its own citizens, people whose children can go to school in that location, who may pay taxes in that location. So if the 30-mile away shelter requires the person to leave his community and to live in another place, that implicates that aspect
I mean, how
of the
far does
problem
that
here.
go? Let's say there are 5 cities all around Grants Pass, and they all have homeless shelters, and yet the person wants to stay. You know, I've been a Grants Pass resident for a long time. I don't want to go to one of those shelters. Can that person be given a citation?
I think because of the concern I've mentioned, I think that would be a serious problem because...
You would say it would be a problem to give them a citation?
Yes, I think so, because you would be requiring, or the city's ordinance requires them to leave the city of Grants Pass. If the homeless shelter is right over the line, they can still be part of the community of Grants Pass.
No, but it's in another city. You keep fighting the hypothetical.
And that's why I think it's different. I'm not prepared to say it, that absolutely not, but I do think it's different because the city is implementing its policy of banishing people, its own residents.
Banishment is a strange word when you're talking about something 10 minutes away.
But again, the question is whether you could still realistically be part of the community where you grew up. The figures show it. In fact, JA 114, 115 here shows that most of the homeless people in Grants Pass are from Grants Pass.
Council, everyone's mentioned, not everybody, many people have mentioned this is a serious policy problem. And it's a policy problem because the solution, of course, is to build shelter, to provide shelter for those who are otherwise harmless. But municipalities have competing priorities. I mean, what if there are lead pipes in the water? Do you build the homeless shelter, or do you take care of the lead pipes? What is there isn't enough fire protection? Which one do you prioritize? Why would you think that these 9 people are the best people to judge and weigh those policy judgments?
We're not suggesting that, and we're not suggesting that the only solution is especially in the current circumstances, the only solution would be to build homeless shelters. As I mentioned, time, place, and manner restrictions, I think, are a very sensible way to go. And in fact, as I mentioned, Oregon state law requires that. In other words, a city adopts a provision that you can't. You can't sleep on the side of school. You can't camp downtown. You can't sleep downtown. You might be able to sleep in a park, and a park, and that could be patrolled for drug use and whatnot. None of these other laws are inapplicable if there's a time, place, and manner restriction.
This is an old question, but eating is a basic human function as well that people have to do, just like sleeping. So if someone is hungry and no one is giving him food, can you prosecute him if he breaks into a store to get something to eat?
Absolutely, absolutely. Breaking into a store is a common crime that not everybody engages in, unlike sleeping, which is what we have here.
But it's a necessity for the person who needs food.
It's not a necessity to break into a store. And with respect to eating,
you're fighting the hypothetical. I'm saying this person needs food.
The Eighth Amendment does not require that person be excused from doing it. I think there's a certain amount of common sense and practicality to this, and it's, I think, well understood that just like drug use is not something the Eighth Amendment excuses you from, either is eating. And the problem of eating is addressed at the local level, as the history and the poor law shows, is that the community takes care of its own residents, and it's common now as it was at the founding for churches and individuals and whatnot to offer their help, the charity in the community. And that's what happens in Grants Pass. Various organizations feed the homeless people, and there are social services to help the homeless people. So this is consistent, except for the absolute ban on sleeping in the city. Otherwise, the community's response is what has been done down through history. But it's the city's absolute ban that interrupts that continuity.
Justice Thomas? Justice Alito?
Could you explain how your rule would be carried out by police officers on a day-to-day basis? Let's say that there are 500 beds in a particular town, and let's say it's 3 o'clock in the afternoon, 4 o'clock in the afternoon on a winter day. What is an individual police officer supposed to do? The individual police officer would go around and count the number of people who are getting ready to sleep outside. I guess if that's 4 o'clock, you wouldn't get that. Let's say it's 6 o'clock. Count the number of people who are getting ready to sleep outside for the night, and then ask each one of them whether you've tried to find a bed at a shelter, whether that person would be willing to go to a shelter if a bed is available, without any conditions, or whether the bed would have to be available on the conditions that the individual wants, like I won't go to a shelter where they won't take my dog or something like that. Just explain how it would work on a daily basis.
Well, first of all, with respect to the individual encounter, I think the way this would work in the real world, I think it's important to understand what happens on the ground in these situations. I think in the circumstances you're talking about, I think what would happen is that the person encountering the homeless person would know whether there is a spot available. I don't think the homeless person would be required to check each day with each shelter if there are multiple shelters. And in larger cities, these initial encounters are not handled by law enforcement. They're typically handled by social services agencies who are in contact with people who are camping and know what their circumstances are. And they are able to say, we know that at such and such shelter, there are beds available. Would you be willing to go?
What if there's a question about whether there are indeed enough shelter beds available? Your rule wouldn't apply if there are enough beds available, right? If there are 500 shelter beds and there are only 200 people who are trying to sleep outside, then your rule wouldn't apply outside.
Right, yes.
So that would be the threshold question.
Right. I just want to clarify one point about that. It's not simply a measure of the number of beds against the number of homeless people, such that if there is a deficit, the city can't enforce the law at all. If you have individualized questioning and you know that there are vacancies available, even if not for everybody, but there is a vacancy for the person being interviewed, then yes, that person, if that person is offered and refuses, that person could be prosecuted. Or cited. So
what if the person says, I know there's a bed available at the Gospel Rescue Mission, but they won't take my dog?
Yeah, I don't think the inability to take your dog to the shelter is a sufficient reason. There are shelters in some larger cities that may well take pets. But
I know I could sleep in the home of a family member, but they really hate me and they're really nasty to me. I'm not. These are. I'm just wondering how this is going to be administered on a daily basis.
And I think, with all respect, I think that example is if the family is going to accept him, but that's the question, whether there is a place to sleep. And I don't know that it would very often come down to that family hates me. On the other hand, if it's a woman who left domestic abuse, she couldn't be expected to go back to her home, or maybe her relative's home, or his relative's home, or something. So there's a lot of common sense. And again, the first encounter that a police officer or somebody else has with a homeless person is very unlikely to be a situation in which the person would be issued a citation.
You mentioned just a couple of things that I wanted to follow up on. Does it matter whether the person grew up in the town or not? Suppose that they go to okay. That's irrelevant. So if they go up to somebody and says, where are you from? Oh, I'm from Fargo, but if I have to sleep outside, I sure would rather do it here than in Fargo. That doesn't matter.
No, and I think not because of any Eighth Amendment rule we're talking about, but under this court's decisions in Edwards and Sines, the Privileges and Immunities Clause or the Commerce Clause or the various right to travel provisions would prohibit attaching that sort of limitation to a newcomer. But I would, as I mentioned, the majority of people are from.
Where I used to live in New Jersey, there are a lot of really small municipalities. I think over 500 municipalities in the state. I could go for a 20-minute walk in the evening and be in 3 or 4 different municipalities. So to get back to the Chief Justice's question, if there aren't enough beds available in West Caldwell, does it matter? Is it West Caldwell's out of luck, even though there are a lot of beds available in Caldwell, which is you know, a couple, less than a mile away?
Yeah, I think the way you're describing it, it might be fair to say that set of small and closely knit communities would be one community, and the person wouldn't basically be banished from where he lived or where he grew up by saying, you know, if there's a shelter in this other location, then you could be expected to go there.
There's some tiny municipalities. What if a municipality doesn't have a park? So if somebody is going to sleep outside, the only place where that person can sleep is going to have to be on the street.
Why?
What does a time, place, or manner restriction work there?
I mean, certainly not on the street, and I mean, because of safety, traffic, et cetera. I mean, there are common sense accommodations, and I think even in the smallest town, there are probably locations where a person could sleep. All
right, thank you.
Justice Sotomayor?
I don't want to be repetitive, but what are we vacating and remanding for? You individualize finding of what?
Well, the way first of all, the class was defined simply on the basis of the aggregate numbers without an individualized determination as to whether, frankly, in our view, not a sufficient individualized determination as to the two named plaintiffs. And you identified several factors here. They both slept in their cars. Several of them were able, or both of them chose at sometimes to sleep at a Safeway parking lot or with a friend. The other slept at a truck stop out of town. It's not clear that neither of them ever actually camped in a park. In fact, the dissent below questioned whether one of those two people even had standing. So that there, even with respect to the named plaintiffs, there was not the sort of examination of their individual circumstances.
So you're talking about standing, that we don't know.
Well, standing, yes, and then there could be typicality or commonality problems there too if the two named plaintiffs slept in vehicles, which may present different problems than in the
Well, we were
in the
told
camp.
that sleeping or camping is out of the case because, and the court said.
Sleeping, yes, but sleeping in a vehicle counts as camping,
Right.
but it's not or a tent or something like that. And it's true, the question of tents are not in the case. And even if the city wanted to allow tents, I suppose it could even require that they be
All right, thank
taken
you,
down
Counsel.
and put back up. There's a lot of flexibility that the city could have.
Justice Kagan?
Well, I did want to ask you just about that. I mean, let's say I'm with you, Mr. Needler, on the fact that you can't prohibit being homeless. And because you can't prohibit being homeless, you can't prohibit sleeping out. This ordinance says, well, but we're prohibiting using a blanket. That can't be right. You know, you're not like just like get hypothermia and the problem will. There are line drawing issues as you go up, right? It's a very cold night and somebody wants to make a fire. It's raining and somebody wants to put up a tarp. The city has said you can sleep in particular areas, but it turns out that those areas have a ton of crime. You know, you could go on and on. And I'm not, how do you deal with questions like that? These are not like gotcha questions. This is like, how do you deal with questions like that? Where is the line where the city can say our legitimate municipal interests can come in and say, you know, as to that, you can't do that?
Yes, well, and there's several examples that you have there with respect to tents and tarps, I guess you were saying. I think there's a difference between what you might need to realistically sleep outside, if it's raining, snowing, or something like that, and what you might prefer to have as a structure for a long-term camping. As I mentioned down in the morning, that's like being in some shelters. say you can stay here overnight, but you have to leave during the day and you can come back. I mean, that might seem gratuitous to the city to do it. It might not want to do it, but we're not saying that the Eighth Amendment would prevent it from doing it, and especially, as you say, if there's no alternative and it's, 20 degrees. And with respect to fires, there are really important issues on the other side of that question. And in an urban area, if you're creating fires, there may be hazards. In a park, there might be fireplaces.
How does a court make these judgments? Because these are tough judgments, and usually they're the kind of judgments that we think of as municipal officials make them. But you're saying, no, there's a certain level where it's out of their hands and it's in the court hands. And I guess I want to know what the principle is, where those questions go to the courts, and why that principle is the right principle.
I think there are two principles. One is that it's the municipality's determination, certainly in the first instance with a great deal of flexibility, how to address the question of homelessness. And a time, place, and manner, and the municipality should be able to choose the place, should be able to choose the attributes of that place, should be able to say we're not going to allow more than 20 people or something, to regulate it in that manner. And I think the principle, the Eighth Amendment principle, would be whether the city has effectively prevented sleeping outside because the protections needed from the elements are not available. And certainly in Grants Pass, I would think even a blanket would not be enough. But I think that's the touchstone. Are you basically, does it boil down to, or is the core principle of Robinson that you can't criminalize homelessness, which includes not being able to criminalize sleeping outside? If you can't sleep outside because of lack of protection from the elements, I think that's the principle a court would apply. But the Ninth Circuit in a number of cases has gone way beyond that, and we think that's rebel of Robinson.
Thank you.
Justice Gorsuch?
Mr. Kneedler, I want to probe this a little bit further, because it does seem to me the status conduct distinction is very tricky. And I had thought that Robinson after Powell really was just limited to status. And now you're saying, well, there's some conduct that's effectively equated to status. But you're saying involuntary drug use, you can regulate that conduct. That doesn't qualify as status. You're saying compulsive alcohol use, you can regulate that conduct in public drunkenness, even if it's involuntary. That doesn't qualify as status, right?
Right.
You're saying you can regulate somebody who is hungry and has no other choice but to steal. You can regulate that conduct, even though it's a basic human necessity, and that doesn't come onto the status side of the line, right?
Yes.
Okay. But when it comes to homelessness, which is a terribly difficult problem, you're saying that's different, and because there are no beds available for them to go to in Grants Pass. What about someone who has a mental health problem that prohibits them, they cannot sleep in a shelter? Are they allowed to sleep outside or not? Is that status or conduct that's regulable?
I think the question would be whether that shelter is available.
It's available.
Well, no, available to the individual.
It's available to the individual.
But
it's just because of their mental health problem, they cannot do it.
I think there might be, that's the mental health
status or conduct.
Well, the mental health situation is itself a status.
Right, I know that.
Yes, but
it has this further knock-on effect on conduct. Is that regulable by the state or not?
I think that if the
all the alcohol, drug use, they have problems too, but you're saying that conduct is regulable. How about with respect to this pervasive problem of persons with mental health problems?
I think in a particular situation, if the person would
counsel. I like my hypothetical. I know you don't. It's a hard one, and that's why I'm asking it. I'm just trying to understand the limits of your line.
I think it would depend on how serious the effect was.
It's a very serious effect. The mental health problem is serious, But there are beds available.
Well, what I was trying to say, it would depend on how serious being required to go into that facility was on the person's mental. If it would make his mental health situation a lot worse, then that may not be something that.
So that falls on the status.
Well, I guess you could put it that way, but I guess what I'm saying is that
that's what I don't know. I'm asking you. I really am just trying to figure out.
You could view that as
You're
status,
asking us to extend Robinson, and I'm asking how far.
Well, what I was going to say, you could think of it as status, but I think another way to think about it, and this is our point about an individualized determination, is that place realistically available to that person?
It is in the sense that the bed is available, but not because of their personal circumstances.
Right, and that's my point. It's available in a physical sense. It may be available to somebody else, but requiring an individualized determination might include whether that person could cope in that setting.
So that might be an Eighth Amendment violation.
Because it may not, yes, because
so
it's not available.
It's an Eighth Amendment violation to require people to access available beds in the jurisdiction in which they live because of their mental health problems.
If going there would...
How about if they have a substance abuse problem and they can't use those substances in the shelter? Is that an Eighth Amendment problem?
That is not
Why?
sufficient.
Why? They're addicted to drugs. They cannot use them in the shelter. That's one of the rules.
Well, if it's the shelter's rule, then they have no, they can't go there if they're addicted. That's not.
So that's an Eighth Amendment. That's an Eighth Amendment violation.
No, the Eighth Amendment violation is prohibiting sleeping outside because the only shelter that is available
is not really available to that person.
Won't take them. Yes, and that's an individualized determination.
Same thing with the alcoholic.
Yes.
Okay, so the alcoholic has an Eighth Amendment right to sleep outside even though there's a bed available.
If the only shelter in town won't take him, then I think he's in the same condition. And there can be all sorts of reasons, and the city doesn't normally...
Judges across the country are now going to superintend this under the Eighth Amendment.
I actually don't think that it requires this. Again, I don't think we should let the Ninth Circuit decisions.
No, you want to
characterize.
Okay, yeah, you don't like the class certification, but that question's not before us, counsel.
No, but all we're talking about is the core principle of Robinson, which is you cannot punish someone for a status. And I think communities guided by that principle, and it's the only principle a court should be enforcing, would retain a lot of flexibility.
How about if there are no public bathroom facilities? Do people have an Eighth Amendment right to defecate and urinate outdoors?
No, we
Is that conduct or is that status?
It's obviously, there's conduct there, and we are not suggesting that cities can't enforce their...
Why not, if there are no public facilities available to homeless persons?
That situation, candidly, has never arisen, and whether or not they're, in the litigation, as I've seen, but no one has suggested, and we're not suggesting, that public urination and defecation laws cannot be enforced because there are very substantial public health reasons for that.
There are substantial public health reasons with drug use, with alcohol, and with all these other things, too.
And they can all be...
You're saying the Eighth Amendment overrides those. Why not in this circumstance? Or
No, I'm not saying the Eighth Amendment overrides laws against drug use.
I know that.
Oh, I'm sorry.
I know that.
No, I misunderstood.
That one the government wants to keep. I got that.
No, I misunderstood your question.
Yeah.
Sorry.
And last one. How about fires outdoors? I know you say time, place, and manner, but is there an Eighth Amendment right to cook outdoors?
No, I think
that's an incident, a human necessity. Every person has to do.
But this is one of those things that is taken care of on the ground as a practical matter. There are restaurants where someone can go.
Well, no, we're talking about homeless people.
No,
they're not going to go spend money at a restaurant necessarily.
There may be inexpensive places. Some people get.
Let's say there isn't. Okay? Let's say that there is no reasonable...
And the local community...
Do they have a right to cook? They have a right to eat, don't they?
They have a right to eat, a right to cook. If it entails having a fire, which I think it probably would, but as I said, the eating, the feeding is taken care of in most communities by nonprofits and churches stepping forward, as they have for 200 years.
But if there isn't, there's an Eighth Amendment right to have a fire.
No, we are not saying there's
Well, I thought you just said there was.
Well, there's food that you can eat without cooking it. They could get a handout from an individual. People can beg for money. I mean, there are ways that this works out in practice.
Last question. I'm totally sympathetic to the idea that there might be a necessity defense in these cases. And there's a footnote in your brief that indicates that in a lot of cases you could maybe bring advanced preliminary injunctive action, at least as individuals. And I don't even see why you couldn't do it on a class-wide
We haven't ruled out class.
basis.
We haven't ruled out class.
Well, I thought you did in that footnote. You said, the whole mistake here is that this was done on a class-wide basis. Why
I think
couldn't
without sufficient inquiry into the individual circumstances is what, in particular.
You just said a minute ago that a lot of this is taken care of on the ground as a practical matter, and I think one of the questions is who takes care of it on the ground? Is it going to be federal judges, or is it the local jurisdictions working with the nonprofits and religious organizations? So I guess following up on the necessity question, given the line drawing problems that we've been going through, if a state has a traditional necessity defense, won't that take care of most of the concerns, if not all, and therefore avoid the need for having to constitutionalize an area and have a federal judge superintend this rather than the local community, which you've emphasized many times, working with the nonprofits and charitable and religious organizations, which is how it works in most places?
Well, I think that the necessity defense, at least traditionally, has required a much stronger sense of urgency and imminence than this. If states had a necessity defense and we knew that it was available in all of these places, but even in Oregon, I think it's a case called Barrett, the court said it's theoretically possible, but there was a remand for factual issues. So we don't know at this point in time whether there is such a defense, and that's really not in the case here. This comes up on an Eighth Amendment challenge without reference to the necessity defense, and frankly without reference to the new Oregon statute, which seems highly instructive in terms of time, manner, and place that jurisdictions grants passed should examine. But I don't think we can. I don't think the court should put this core point about Robinson to one side because of the possibility that in Oregon and maybe no other place, I don't know about, California law of necessity, maybe it would be taken care of. I think at this point in time, that is too
Well, usually we think about before constitutionalizing an area or extending a constitutional precedent, you might disagree with that characterization, but before doing that, we usually think about whether state law, local law already achieves those purposes so that the federal courts aren't micromanaging homeless policy, and it's on a daily basis when you work with the homeless. It's a daily issue. How many people are going to show up that day at the food bank? How many people are going to show up that day at the shelter? So it's not like this is a once-a-year thing.
Yeah, no, for the people actually dealing with it day to day, that is certainly true. The city, the law enforcement, the city liaisons, the nonprofits, but it's not true for the federal court. The federal court doesn't have to get into any of that. The only time the federal court would get into it is if the core principle of Robinson was being disregarded by criminalizing somebody for sleeping outside when they have no place to sleep inside. That's the core principle. That's the only thing a court should be enforcing, not whether people show up. And another thing I would say about the necessity defense, it may be that if the court issues an appropriate injunction in this case or another case limited to the core principle of Robinson, but it develops, or the state law develops, that there is a necessity defense, then I think that should be taken into account. And, I mean, that's in effect a time, manner, and place or similar to that. If state law comes along and establishes a realistic defense or a realistic approach to how people can remain in the community, then the courts obviously should defer to that. But we don't have that established state law at this time. And I don't think the court should decline to address this question, which is important in the Ninth Circuit, both because the principle that those courts recognize should be sustained, but the approach they've taken should not.
Last question I have on the food hypotheticals about stealing to feed yourself or cooking to feed yourself. You kind of waved all those away by, oh, that's all taken care of by local communities, nonprofits, and religious organizations. And by and large, heroic efforts each day to make sure that happens, but it doesn't always happen by any stretch.
No, it doesn't always happen, but homeless people are resourceful. They have friends who are also homeless. They may know people in town. They may beg for money. And the towns are coping in the same way, frankly, that individual homeless people do. They do the best they can under the circumstances. But that if those circumstances fail and the nonprofits, et cetera, can't, the truck doesn't show up one night, that doesn't become an Eighth Amendment problem. And we're by no means suggesting that there should be a federal judiciary overlay on top of all that. The cities and the nonprofits should be left alone to do the work that they're doing, unless the core principle of Robinson is not respected.
Thank you.
Justice Barrett?
So one odd thing about the posture of this case, putting aside the class part, is its pre-enforcement nature, because in Robinson and in Powell, too, the punishment, the adjudication of guilt had already occurred, and it was time for the punishment to be imposed, and then the Eighth Amendment challenge was raised. And Justice Alito was asking you about a lot of the very difficult on-the-ground factual determinations that law enforcement would need to make before deciding whether someone could be given a citation for camping outdoors. Why wouldn't it make more sense, assuming that we agree in substance with the line that Robinson would control here, why wouldn't it make more sense for the Eighth Amendment claim to be erased as a defense, much like the necessity defense, once a court is in a position, unlike the law enforcement officer just trying to gather information on the ground to determine whether there were available beds, whether the person had a place to go? Why is a pre-enforcement challenge the right way to think about this?
Well, several things. It obviously could be raised as a defense in a criminal prosecution or civil citation.
Sure, but does it make sense to think about it?
But I think for this particular Eighth Amendment claim, the claim is that the Eighth Amendment prohibits criminalizing the act to begin with. So it's not just the punishment that would be
well, I mean, I understand that. I mean, let's see. I do understand that, but it's not that it categorically prohibits punishing this act. I mean, as one might say, if it, prohibited sleeping altogether for everyone, right? This is because the Eighth Amendment claim is that it criminalizes this act in a way that falls disproportionately and unconstitutionally on a particular class of people. And that requires adjudication at the front end to figure out whether someone is protected or unprotected. If I go and sleep in an encampment, I can be cited. It's different. There's a factual determination on the ground. And Robinson was a status-based challenge, and it came up in the context of the individualized criminal proceedings. So why is a pre-enforcement challenge, why does it make sense given the very, very fact-intensive nature?
Well, and in an individual case, I think you're right. But imagine a situation where someone who genuinely had no other place to live, and it's the third citation, the fourth citation, and you have a pattern as to that person or other people where the city is consistently not respecting the Robinson principle, then I think you might have a pre-enforcement review just as you might for an asserted violation of some other constitutional right. Because here, again, it's not the Eighth Amendment regulating only the punishment for an otherwise valid conviction. Here the question is whether the city can criminalize that conduct at all. And so if you have a series of citations that don't rise to the level of probable cause or whatever would be necessary for the issuance of a citation, where the law enforcement officer on the ground is not respecting the Robinson principle, then you might have an injunctive action.
But this would be the first case, right? Because it didn't happen in Robinson itself, where we had a pre-enforcement challenge on the basis of the Eighth Amendment to the criminalization of certain conduct. putting policemen in this situation, right?
But I suppose in Robinson itself, if the person had been arrested once, been arrested a second time, and then he's arrested a third time, I would think he could bring a pre-enforcement challenge because the way the police were interacting with him was not respecting the Robinson principle with respect to Robinson himself.
How does the federal government do this? So in the brief, you talked about clearing the encampment at McPherson Square. Can you just describe, I mean, briefly, if you can, I mean, do police then make individualized inquiries? How does this work?
What happened there was I think the gold standard of the way this should be done. And in larger cities have this ability that the Park Service cooperated very closely with the district government. The Park Service does not have the sort of social services, et cetera, that a municipality has in D.C., and so that function is sort of split. These are special national park properties, but the National Park Service relies, as the federal government does, the Federal Protective Service for buildings elsewhere, cooperates with the local government, and the local government social service people or the nonprofits went out and interviewed everybody who was in the encampment at McPherson Square, and told them about what services are available. There was advance notice given that the encampment is going to be cleared within, I think it was 30 days, and people were warned 30 days in advance. They were warned the night before, the day before, so they could collect their things. Some just moved somewhere else. Some did take the city up on the offer. Some went in to shelters. And that's the way that encampments are typically cleared. And particularly in cities where you've gotten a number of amicus briefs explaining the problem. That's what happens. It isn't the example we've been talking about where the law enforcement officer for the first time is encountering the person. Smaller cities don't have that capability, but Grants Pass does have these outreach workers, and that's who carries on the dialogue. And so that's the way it was cleared.
Justice Jackson?
And so given that experience and the fact that Martin has actually been the law since 2018, we don't really have to speculate as to how this works, right? I mean, this is the law right now in the Ninth Circuit.
The Robinson principle.
The Robinson principle as adopted in Martin. My understanding is, for example, California says that's the law, we comply with it, and there we are.
Yeah, they are not asking for Robinson to be overruled. What they're objecting to is the injunctions that go well beyond that.
Yes, I understand. I'm just sort of responding to some of the questions that you've gotten as to sort of how does this rule work? Can it work? That sort of suggests that it's not already happening on the ground in these places, that the shelters and the workers are aware of what is available, that people are being advised, that, the principle of Martin, at least in the Ninth Circuit, is we hold that so long as there's a greater number of homeless individuals in a jurisdiction than the number of available beds, the jurisdiction cannot prosecute homeless individuals for sitting, lying, sleeping. This is not a new rule. That's what the law is right now in that situation, right?
Yeah, that's what I don't want to say that the clearance procedures work perfectly in every case or that they're available in every case.
No, I just want to say we don't have to speculate about how the rule works. It's not a new thing that is being asked for today.
How it's supposed to work. All I'm saying is that there may be imperfections.
All right, let me ask you about whether or not you are asking for an extension of Robinson. That's come up a couple times, and I don't see it as an extension or whether that's being asked for. So can you explain whether there's some sort of extension of Robinson happening today?
No, I don't think so at all, because as I said, the sleeping outside is an essential human function, and if you say someone can't sleep outside, that's sort of or has no place to sleep inside. That's the definition, really, of homelessness.
So you're not suggesting that people should be excused from engaging in otherwise criminal conduct. So we've heard this example about people stealing in order to eat. I mean, that would be a situation in which someone is actively participating in what would be otherwise criminal behavior if anybody did it.
Yes.
And the idea, I guess, is that, well, maybe these people need to do it, and so that might be some sort of excuse. That's not what's happening in the facts here, correct?
No, that's correct. And one thing that I think is important to keep in mind in this is if Grants Pass can do this, so could every other city. So could a state do it statewide. And eventually, a homeless person would have no place to be.
So this is
lawfully
more
be.
like the sort of initial hypo of criminalizing eating outside, not that you'd be doing something that was otherwise criminally culpable.
Yeah, yes, I mean, I suppose there could be ordinances that the city would have about where you can, you can't eat it, can't consume.
That's
food
time,
that-
place, and manner. Final question, with respect to, you mentioned states doing this. Why isn't the federal government arguing that this case is moot in light of 195-530? This is the Oregon recently passed statute that I mentioned earlier. Why doesn't the government read that law as I do to prevent Grants Pass from enforcing its ordinances to block sleeping outdoors at all places and all times?
Yeah, no, I certainly agree that there appears to be a pretty stark inconsistency between that state law and the ordinance. It hasn't been applied. It has to be objectively reasonable.
So would the federal
this
government-
isn't time, place, and manner at all.
Right. So what would your position be if the court decided that as a matter of constitutional avoidance or whatever else, that we don't need to hear this or reach this decision in this case, given this new state ordinance?
That would be one possibility. It wouldn't answer the core Robinson principle point and the limitations on that point that has triggered the amicus briefs.
Right, but our typical rule is
Yes.
that if there's some other way, we don't necessarily comment on constitutional issues, correct?
And yes, and that would be one course to see what time, place, and manner meant under state law and how the Eighth Amendment could accommodate that or take it into
Thank you.
account.
Thank you, counsel. Ms. Corcoran?
Mr. Chief Justice, and may it please the court, Robinson v. California holds that status-based punishment schemes are categorically cruel and unusual under the Eighth Amendment. The challenged ordinances inflict status-based punishment in both effect and purpose. Although the city describes its ordinances as punishing camping on public property, it defines campsite as any place a homeless person is while covered with a blanket. The city interprets and applies the ordinances to permit non-homeless people to rest on blankets in public parks, while a homeless person who does the same thing breaks the law. The ordinances, by design, make it physically impossible for homeless people to live in Grants Pass without facing endless fines and jail time. The only question under Robinson is whether there's any meaningful difference between a law that says being homeless is punishable and a law that says being homeless while breathing or sleeping or blinking is punishable. In other words, does adding a universal human attribute to the definition of the offense make the punishment conduct-based instead of status-based? The answer is no. The purpose and effect of the second statute is exactly the same as the first, to make people with the status endlessly and unavoidably punishable if they don't leave Grants Pass. Indeed, all the ordinances do is turn the city's homelessness problem into someone else's problem by forcing its homeless residents into other jurisdictions. The injunction below leaves the city with an abundance of tools to address homelessness. It can impose time, place, manner restrictions on when and where homeless people sleep. It can ban tents and clear encampments. It can enforce a sleeping ban against homeless people who decline shelter. And it can fully enforce its laws prohibiting littering, public urination and defecation, drug use, and violent or harassing behavior. The only tool the city wants that it doesn't have is authority to impose a 24/7 citywide sleeping ban that forces its homeless residents to either move to another jurisdiction or face endless punishment. The state police power is broad, but it does not include the power to push the burdens of social problems like poverty onto other communities, or the power to satisfy public demand by compromising individual constitutional rights. I welcome the court's questions.
In Robinson, there was a statute that said that to be addicted is a crime. Is there an ordinance here that says to be homeless is a crime?
So the language for the purposes of a temporary place to live bakes homelessness into the definition of the offense. Justice Sotomayor was talking about that earlier. So when you combine that language with the rest of the camping definition, what you have is an ordinance that says being homeless while sleeping with a blanket is punishable. And as I just said earlier, the question becomes, when you attach the status to the universal attribute of sleeping, does it then transform the offense into a conduct-based punishment instead of status-based punishment? I think the answer is no.
A number of us, I think, are having difficulty with the distinction between status and conduct. You'll acknowledge, won't you, that in those terms there's a difference between being addicted to drugs and being homeless? In other words, someone who's homeless can immediately become not homeless, right, if they find shelter. Someone who is addicted to drugs, it's not so easy. It seems to me that in Robinson, it's much easier to understand the drug addiction as an ongoing status. Well, here, I think it is different because you can move into and out of the status, as you would put it, as being homeless.
Yeah. So it's interesting, we today understand addiction as an immutable status. In Robinson, the court suggested that someone might be recovered and no longer have the status of addiction. So the Robinson court wasn't thinking about addiction as something that couldn't change over time.
Well, that may limit the applicability of Robinson to a different situation, but what is the analytic approach to deciding whether something's a status or a situation of conduct?
And so the question is, a status is something that a person is when they're not doing anything. So being addicted, having cancer, being poor are all statuses that you have apart from any conduct.
Having cancer is not the same as being homeless, right? I mean, maybe I'm just repeating myself, because homelessness you can remove the homeless status in an instant if you move to a shelter or situations otherwise change. And of course, it can be moved the other way as well if you're kicked out of the shelter or whatever. So that is a distinction from all these other things that have been labeled status, isn't it?
I don't think so, because, you know, a cancer patient can go into a status. It's something you are apart from anything you do. It's a status that can change over time, and at that point you wouldn't be a part of the class. But I don't think it changes the fact that it is a status. And what Robinson found so offensive about status—
Well, I guess is being a bank robber a status?
No, because being a bank robber means you rob banks. So the definition and the conduct—
Violating this ordinance means upon being asked to leave, you don't leave.
Violating this ordinance means you're homeless. So again, homelessness is not something you can that you do. It's just something that you are. And so the question becomes, when you attach the universal human attribute of sleeping or breathing to that status, does it make the punishment conduct-based instead of status-based? I think the answer is
Counsel Edwards v. California in 1941 struck down a law that made it a crime to transport an indigent person, correct?
yes.
Indigency is a condition that can change over time, but the law was aimed at the transport of a person who wasn't morally reprehensible.
Yes, I think that's notable because our history and tradition as a country is to emphatically reject any sort of local legislative scheme that has the effect of pushing the burdens of poverty or indigency into other communities. It's woven throughout our Constitution. So Edwards located it in the Dormant Commerce Clause. We have Science v. Roe, which locates it in the Privileges or Immunities Clause. Papa Christou addresses a status-based punishment in the context of a procedural due process. What Robinson held is that when that expulsion is effectuated through status-based punishment, it violates the punishment clause.
How do you define a community? So Justice Alito was describing how New Jersey has so many tightly woven municipalities close together. And here, the Chief Justice was asking about whether if grants pass if there was a new homeless shelter with lots of beds right across the border 10 minutes away, could that be taken into account? And I think there was some back and forth and not necessarily agreement on that. What is your position? How do you define a community? Take that example of a homeless shelter right outside the limits of Grants Pass.
Yes. So to answer that hypothetical first, I'm not concerned. I don't have any problems with saying that a homeless person in Grants Pass has legal and physical access to a shelter that's just over the lines, if that's in fact true. Lots of jurisdictions limit their homeless shelters to people who are residents. So, and just to be clear, there was no suggestion in the record here that there were any shelters available outside of Grants Pass.
Understood. But so community doesn't need to be determined by jurisdictional lines, is what you're telling me, as a matter of because let's see, I'm asking all of this because in response to Justice Sotomayor, you were pointing out that our nation has a history and tradition of not saying you can shunt homeless people or the poor out of your jurisdiction and onto others. So, or out of your community and onto others, is I think how you phrased it. So I'm asking, how do we know what those lines are? And you're saying it doesn't have to be jurisdiction specific.
No, I think jurisdiction matters because that tells us kind of the lines in which whatever ordinance or statute applies. So when shelter is available, the ordinances are enforceable because they punish the conduct of not going to the shelter as opposed to the status of homelessness. So I think that a municipality can punish the conduct of not going to a shelter that's just over the line if you have physical and legal access to it. Now, for the reasons you say, and this dates back to our settlement system at the founding era, a lot of municipalities do not allow people from outside of the jurisdiction to use their shelters. And so under those circumstances, the shelter wouldn't be legally available.
Is that cruel and unusual punishment for them to turn away someone who wants to use their shelter?
No, that wouldn't be punishment. Punishment is the infliction of suffering for a crime.
Counsel,
Well, then why is the Eighth Amendment implicated in this case?
Because here we have fines and jail time. We have a status-based punishment scheme that is, in fact, inflicting punishment within the meaning of the Eighth Amendment.
Counsel, do you want to, I'm sorry, Chief.
No, I'm done. That's fine.
Do you want to address some of the line drawing problems that we've been going back and forth? I mean, Justice Gorsuch pointed out, eating is a basic human need, and it's not the case that soup kitchens or social services will always be able to meet it. And so he asked about whether the Eighth Amendment would prohibit punishment for stealing food. You might ask the same questions about trespass and squatting in structures if they're, if that was the best alternative. So how do we draw these difficult lines about, public urination and that sort of things?
So I'll start with stealing food. Stealing food is not part of the definition of homelessness, and it's also not a universal attribute. So I would put that outside the scope of any of the arguments we're making here. With respect to public urination and defecation, if you had I don't think this would ever exist, but if you had a law that said homeless people cannot urinate or defecate anywhere within city limits, I think then it starts to look like this case. But if you're saying that people can't urinate or defecate on public property, it's hard to imagine a situation where
to go. So a homeless person, there's no facilities available, and a homeless person has no place else to go.
You might have there are commercial establishments. I don't know that anyone's pointed to a jurisdiction where you truly don't have access, but if we
what's the constitutional principle?
Right.
Take my hypothetical. Say there's not commercial establishments, don't want non-patrons coming in to use the facilities, there are no public facilities, and it's a generally applicable rule that says no public urination.
So I think one distinction between urination and defecation and sleeping is that sleeping outside is part of the definition of homelessness, right? Homelessness is lacking a fixed regular nighttime address. So the sleeping prohibition goes more directly to the status of homelessness than urination or defecation.
So it would not violate the Eighth Amendment to punish public urination and defecation?
You might come up with some different theory, but it's not the theory that we're
not the theory that you're,
yes.
Okay.
What do you think, Ms. Corcoran, of this idea that Oregon's necessity defense essentially functions as an Eighth Amendment in this context, so we don't have to constitutionalize the kinds of limits that
Pointed out, there is a necessity defense in Oregon law, but so far the Oregon courts have not applied it to this circumstance. It also wouldn't necessarily be available for the fines, the citations we have here. But I think that this question about the availability of the necessity defense really goes to the injunctive posture of the case. It's not going to come up if you're in the, if you're presenting the Eighth Amendment as an affirmative defense at the same time as a necessity defense in a criminal prosecution, right? It kind of moots out the Eighth Amendment claim. But going to Justice Barrett's questions about injunctive relief, there the question you're asking is, does the plaintiff have a credible threat of future punishment? I'd say first that the injunctive relief is not before the court. The city has not challenged the propriety of the injunction here, so I think it's a question for another day. The courts here did find that the plaintiffs had shown a credible threat of future punishment, and so I think that resolves the issue for this
Counsel,
case.
along those lines, we haven't mentioned it yet, but in the briefing there's a lot of discussion about the fact that Robinson's Eighth Amendment holding with respect to status came without any adversarial testing. It wasn't what was argued by the parties. It didn't have a whole lot of citation or support. It came kind of in a breezy paragraph.
Right.
And some have suggested that that's really a mistake because the Eighth Amendment's about punishments. It doesn't limit states' capacity to engage in passing laws that make conduct or actions or anything a crime. It just goes to the nature of what punishments follow, putting aside the excessive fines clause.
Yeah.
So there's a lot of discussion in the brief about that. And some suggestion that really it's the 14th Amendment that should be doing work here, if there is work to be done, because some form of the necessity defense has been always understood as inhering in due process from the founding. And whether that can be enforced through state laws, which might differ, Kansas versus Collar, but have to nonetheless cover the territory, and whether there might be injunctive relief on that basis, possible in advance, not limited to defenses, possible. Well, just reactions to that. We haven't yet touched on.
So Robinson predates Graham v. Connor, but I think it espouses the same principle, which is when you can identify an explicit textual source for a right, you locate the right in that amendment and not more generalized notions of due process. And so what the Robinson court did was say—
Here, the more limited, I mean, let me just play with that for a minute. The more natural home for a necessity type argument is due process. That's where it's always historically been understood to lie, not an amendment having to do with punishments, right? One has to do with what you can criminalize, the other has to do with the punishments that follow. And you're not really attacking the punishments here. You're saying any punishment is impermissible.
Oh, right.
And any punishment's impermissible. And that is a necessity defense. That's a classic necessity defense.
So I think that it's right that Robinson describes what it was doing as saying that the Eighth Amendment prohibited the criminalization. You see that language in, I think, Weems and Wilkinson v. Utah. I agree it seems like a bit of a strange fit.
If that's the case, if that's the case, let me just, wouldn't that get rid of this awful status conduct distinction that we're struggling with here today? Because if it's a necessity, it doesn't matter why it's a necessity. Every person can make their own argument about why it was necessary, and then the courts will decide. We don't get into this status conduct stuff that Robinson seems to invite.
Well, but here we don't have necessarily a necessity defense, so that wouldn't be very satisfying.
You don't think your clients have a good necessity defense?
The Oregon courts so far have not applied.
I didn't ask whether the courts have applied it. You haven't asked them to apply it.
They've had a couple of cases like this.
Have they?
Mr. Neither referred to the Bartlett case.
And how are they going?
So far, they have not applied the necessity defense. They left open the possibility that it might apply, but they haven't applied it
Why not?
yet. They didn't find that it was necessary under those circumstances. And again,
Did they rule out that it might be necessary under some circumstances?
they left open that possibility, but I'd also say the civil citation, or I don't want to say civil, it's a little murky, but the fines here are not subject, I don't think, or it's not clear, to the necessity defense. So it wouldn't take care of the
You got
entirety.
excessive fines clause there, though, right?
Yes.
And that's not before us either.
We have raised the fines before this court because our challenge is to the package of punishments, and historically, that's how the court has looked at applying the excessive fines clause and the punishment clause together. We're in a really unfortunate posture here that we have claims that involve both fines and punishment, and yet we're only here on the punishments clause piece of it. It was one of the reasons we suggested this isn't a great vehicle. I think the court can say that it's not going to reach the fines because we won on that below, and so you can just focus on the jail time for criminal trespass.
What is your definition of stay indoors on a particular night, or is it something broader than that?
So homelessness.
Does it require more than that?
Right. Homelessness is defined as lacking a fixed, regular, adequate nighttime address. So if you have a home, you have a home. I'm not homeless when I go to Grants Pass because I have a home in D.C. The second part of our class definition focuses on whether the homeless person has access to shelter. That's not because that's part of the status. It's because when someone has access to shelter, then the ordinances aren't punishing them for the status. It's punishing them for the conduct of not going.
Well, I ask the question because if homelessness is defined as simply lacking a place to stay indoors on a particular night, then there is an ironclad connection between the conduct, which is sleeping outside, and the status of homelessness. But if homelessness is defined to require more than that, then my question would be whether someone who is lacking a place to stay on a particular night or for a particular period of time is homeless if the reason why the person finds himself or herself in that status is, for example, the person refuses to take antipsychotic medicine that's been prescribed, or refuses to go to drug rehab, or rehabilitation for alcoholism, or the person has chosen to move from one place where the person might have a shelter or a home where the person could live to another place. What about all of that?
So the status of homelessness is something that only changes once the person has a home. You lose your home, you're homeless. If you have a home again, then you're not in the status anymore. I think what your question gets at is that second piece, which is whether a person has access to shelter. That can change from day to day. And so—
No, that's not really what my question gets at. The question is, you can draw a distinction. Status is different from conduct. But there are some instances of conduct that are closely tied to status, or if homelessness is defined as simply lacking a place to stay on a particular night, they amount to the same thing. The definition of homelessness encompasses the conduct of sleeping outside. So my question is whether this is, what if the person finds that person in a homeless state because of prior life choices, or the refusal to make future life choices? That's the question.
Yeah, so our definition of lacking access to shelter is lacking physical or legal access to shelter, and you're looking at the person's situation on that particular night. I think generally we're not doing an inquiry into all of a person's life choices that might have led them to the point where they're homeless and can't find a place to sleep. Robinson certainly didn't do that sort of analysis with respect to addiction, but there could be situations where there is such a tight causal nexus between a choice a person has made and their lack of shelter access that you would say this person has chosen not to take the shelter. And to be very clear, if you decline shelter that is physically and legally available to you, you're not in our class.
Well, see, the problem is that once you move away from the definition that makes the inquiry basically tautological, then you get into the question of assessing the closeness of the connection between the status and the conduct. And you do run into problems with the person who's a kleptomaniac, or a person who suffers from pedophilia. So how do you distinguish that, how does the court assess how close the connection has to be?
So for both of those categories, the status is defined, I don't know if status is the right word there, being a pedophilia or having pedophilia is defined by the urge that you have, not by your conduct and acting on that urge. So if someone were to act on that urge, and then you had that tight causal nexus and why they didn't have access to shelter, then they would be outside of our claim.
I thought you made a very interesting remark in response to Justice Alito, and I'm just trying to clarify. You seem to say that homelessness, as you've defined it, is not lacking access to shelter on a particular night. Am I right about that?
That's right. I use the HUD definition, which is that homelessness means you lack a fixed, regular, adequate nighttime address.
So that kind of thing might, going back to the Chief Justice's original question, that's not changing night to night in the same way.
I mean, it can change over time in the same way that a cancer diagnosis could change over time, but...
And then the other part that was interesting to me is that assuming that's your definition, homelessness lacking a fixed, regular address, when someone does have access to a shelter, even though they lack a fixed, regular address, the ordinance in that situation, I thought you said, is operating to punish the act of not going to the shelter.
Yes.
As opposed to punishing the
a problem, because if you have time, place, and manner restrictions, what you're doing is punishing the conduct of not going to sleep where you're allowed to go. That rationale doesn't work when someone has nowhere to go.
And can you speak to whether or not we should really be even getting into this in light of the new Oregon law?
So we didn't argue mootness. We made this point in our brief in opposition. We didn't say mootness just because we don't have an injunction under the Oregon law yet, and it's not self-executing. I don't think there is any question that the ordinances fall under the Oregon law. I mean, it was intended to codify Martin. It requires that any sort of restrictions on sleeping or resting outside are reasonable with respect to homeless individuals. Clearly, the ordinances here don't meet that standard. So I certainly wouldn't have any concerns with the court saying, as a matter of constitutional avoidance, it appears this Oregon law resolves this whole issue. So we're dismissing as improvidently granted, or however the court wanted to resolve the case.
Thank you.
The plaintiff who died here had used up her provisional stay credits at the time of class certification, so she no longer had a shelter who was willing to take her. I think the hard hypothetical that Justice Alito was positing, and in part Justice Gorsuch, is the person who owns a dog.
Yeah.
Or let's say a mentally ill person. Do you have the same response as the government?
So I would like to live in a world where separating someone from their pet is cruel, but it's outside the scope of our claim because we are just talking about physical and legal access to shelter. So if someone turns down a shelter offer that's physically and legally available because of their dog, they would not be within the scope of our claim. To get to the mental health hypothetical, if the person's mental health issues made the shelter either physically unavailable to them, because if they went there, they would be at substantial risk of bodily harm or death, then I would say the shelter isn't physically available. You could also have a shelter that won't take people with mental health problems, in which case it wouldn't be legally available to them. I would say that if the shelter is physically and legally available, then they're outside the scope of our claim, but they might have ADA claims or some other law that applies that would restrict the city's ability to punish them for not going to that place, but it's outside our case.
Thank you, counsel. Can you go from having a fixed regular address to not having one?
Yes.
Can you go from not having one to having one?
Yes,
Thank you. Thank you. Justice Thomas?
In Robinson, a narcotics officer testified that based on his experience, the marks on the defendant's arm suggested that he was an addict.
Yes.
Do we have anything like that where an expert testifies that the individuals here are homeless?
So here the legal burden was on the plaintiffs to show that they were homeless. The lower courts found that their declarations and depositions
Well, what I'm
satisfied
interested in is the status. You say that this is the equivalent of Robinson, and I'm trying to determine where the status of homelessness was determined and how it plays a role in this case.
So it was determined based on the declarations and depositions of the putative class members and named plaintiffs. It also, we've talked a little bit about the ratio between beds to population. The Ninth Circuit ended up rejecting that as a hard and fast rule, but the lack of shelter beds in Grants Pass provides credibility to the putative class members' declarations when they say they have nowhere to go. I'd also say I don't understand the city to have ever contested that the named plaintiffs are homeless. What they contested is whether they had access.
I think what's confusing me is that when I read the ordinance is an anti-camping ordinance. Would this happen? Would a backpacker who happens to be in the area for a few days be allowed to camp on public property?
I think theoretically, no, but I would say that the city has never, it was not able to identify any circumstance in which it had applied.
Well, I understand that, but it would apply to a backpacker.
So it would depend on the circumstances. The line that the police officers drew in their depositions was that if they saw a non-homeless person lying on a blanket, they wouldn't enforce the ordinance.
No, I'm saying someone with a backpack who's been wandering around for a couple of years in the Continental Divide or something.
So I can imagine, I'm putting myself in the place of the officers who were deposed. If you gave them that hypothetical, they might say, no, that person isn't setting up a temporary place to live. They're just traveling through town. That particular hypothetical didn't come up. But
So that would not violate the anti-camping?
I don't know. I mean, maybe this gets to the vagueness of the provisions, but.
Justice Sotomayor, Justice Kagan, Justice Kavanaugh?
I think one of the premises of your argument is that this is not good policy for the homeless. Good policy would help homeless individuals transition, get mental health treatment, get substance abuse treatment, job assistance, and that this doesn't fulfill those objectives. And maybe you're not saying that, but I'm curious whether you think this is good policy in terms of incentivizing or bad. You must think it's bad, and I'm curious why.
Yeah, I don't think we've made that argument. It's certainly a theme across the amici briefs. I would, just on the incentivizing, I think is a non sequitur, because the only question here is whether it violates the Eighth Amendment to enforce the ordinances when someone has no access to shelter, when they're turning down the services. So that's the circumstance we're looking at. I think what your Honor's question gets at is our discussion of no penological purpose. This court has recognized that when a punishment scheme has no penological purpose, it inflicts gratuitous suffering. And that is cruel and unusual punishment. And I will say at this point, the city has not ever identified any penological purpose for punishing homeless people who do not have access to shelter. If you ask that question, every time they pivot to encampments and fires and sanitation problems, which are all non sequiturs, as I've said a number of times, this case is only about sleeping outside when there's no shelter available. And so I think that lack of penological purpose is significant.
Well, we've heard a lot about how it's more difficult to have an effective homeless policy given the rule that's been in effect in the Ninth Circuit over the last several years.
I think that's flatly wrong. I mean, I'll go back to my opening. I gave the whole list of the things that the city is allowed to do under the ordinance and under our claim. The only thing that they cannot do is impose a 24/7 sleeping ban that makes it impossible for homeless people to stay in the jurisdiction. I'd also note, they have a lot of amicus briefs on their side from local governments. Almost the entirety of what those amicus briefs are complaining about isn't at issue in this case. So when you have injunctions against encampments, that's under the Fourth Amendment. We don't have a Fourth Amendment claim. A lot of the injunctions are under the 14th Amendment, including the San Rafael one that the city identifies in its reply brief. I think it's remarkable that when the city was trying to identify the best example it could come up with for its reply brief, it chose one involving a different constitutional claim.
Thank you.
Justice Barrett? Justice Jackson?
Can a person go from being addicted to drugs to not being addicted to drugs?
So I think under common, as we think about it in terms of modern medicine, the answer is no. But the Robinson court certainly thought that was the case, right? 60 years ago, we didn't have the same understanding of addiction.
So your view of Robinson is that it doesn't really matter the permanency of the condition, it's still a status.
Right, the Robinson court did not think that the permanency mattered because it thought that addiction was a status that could change.
Thank you.
Thank you, counsel. Rebuttal?
Thank you. This case is worlds away from Robinson. The Eighth Amendment does not answer any of the questions that we've been discussing today, and that is reason not to extend Robinson. All of these questions are unanswerable. First, I'd like to start with the United States' position. That would also bring chaos. It would be a disaster if Martin were to remain on the books in any form. It does not make a difference if the inquiry is pre-enforcement or post-enforcement. All the same questions come up about whether the person's conduct is involuntary, what their choices are, how they are there, whether the shelter that's available is adequate, where it is, what rules it has, all of that. And I'd like to clarify how all of this works in practice, because it would be impossible for people on the ground to understand and predict what a court would say about the shelters that are available and the alternatives that are available and the choices that were made and the difficulty of all that. So here, how it works is under the grants pass policy. I'll direct the court to page 155 of the joint appendix. There it says officers are required to give a 24-hour notice before issuing a citation. So I want to just focus on that for a moment. How will the officer know when she or he comes back whether the individual has another place to go? There's no way to know the answer to that. So they would have to take their word for it, perhaps. So it would lead to all of those same problems. And it is hyperbole. The other side talks about banishment, that going on here. They talk about an isolated statement from a community meeting. That was a 3-hour meeting. There are 20 pages of minutes. It's one sentence. What that full context shows is a wide-ranging discussion about all of these difficult policy problems and how the city was trying to incentivize people to accept shelter and dealing with a small group that was causing serious problems and crime in the city, and they're trying to balance those who wouldn't take the help with the city's needs to keep their public spaces open. When the Ninth Circuit constitutionalized this area, it left cities with really no choice. Either keep, build, force to give up all of your public spaces. That is what's happened. We've seen a suspension of enforcement of these basic laws that are so important. The line drawing problems are never ending. That is exactly why Powell, Justice Gorsuch, to your point about Powell and the plurality there, said that if we embark on this journey and we start constitutionalizing laws that address conduct, the line drawing problems will be endless. And so that is a reason not to extend Robinson here. So I just want to make, again, our basic Eighth Amendment point here, which is that these are low-level fines and very short jail terms for repeat offenders that are in effect in many other jurisdictions. This is not unusual in any way. It is certainly not cruel. And we can just point to our appendix in our reply that goes through jurisdictions from West Hollywood, California, to Watertown, Massachusetts, that have the same type of policies. So the policy questions in this case are very difficult, and I think that's what has come across today. The Eighth Amendment question, though, is not. Here, the punishments are the sorts of punishments that have been held to be permissible since the founding and really are in use today. They're not in any way unusual. So we heard a lot of things about guessing how this would work in practice, but it sounds to me like courts would need to have some sort of rules so that they could tell a jurisdiction like Chico that the place it set aside for camping was adequate when the federal court said no, it wasn't because it's outdoors, or San Clemente that was threatened with lawsuits because it didn't provide cell phone chargers in the area that it designated for camping, or San Rafael, where the court said that 200 feet between tents was too much and that 100 feet was the maximum under the Eighth Amendment. So for all of those reasons, the court should reverse.
Thank you, counsel. The case is submitted. We'll hear argument next in Case 22-1218, Smith versus Spizzeri. Mr. Geiser.
Thank you, Mr. Chief Justice, and may it please the Court. Section 3 unambiguously mandates a stay pending arbitration, and the FAA's plain text, structure, and purpose confirm that conclusion. Congress directed that a court shall stay the trial of the action until the arbitration is complete. There is no mention of dismissal, and there are no exceptions for cases where all claims are subject to arbitration. If a court ignores that command and dismisses, it activates a premature right to appeal contrary to the FAA's reticulated scheme. It eliminates the essential backdrop that protects litigant rights if a party compels arbitration but abandons the arbitration process, which has happened in this very case. And critically, it invites wasteful disputes that pointlessly burden parties and courts, as litigants fight over whether to stay or dismiss, and then take appeals over whether to stay or dismiss. A bright-line rule answers that procedural question in a manner that best preserves judicial and party resources and directly advances the core purpose of the FAA itself, eliminating waste, avoiding unnecessary litigation, and sending parties to arbitration as quickly as possible. I welcome the Court's questions.
Mr. Geiser, what difference does it make to grant a stay here or dismissal without prejudice?
Well, it makes a big difference whether we have a suit to come back to. The arbitration has now failed. The respondents have not paid their fees. Our clients will have to file new suits, engage in new service, do new case-initiating documents, and waste our time and the court's time. We also face a situation where respondents could then move to compel arbitration again. And further,
but aren't you also encouraging people to start out in federal court?
I don't believe so, Your Honor. That hasn't been a problem in any of the 6 circuits that have adopted the majority rule now for quite some time. Even if a party did file a suit in the hopes of anchoring federal jurisdiction, the court could always decline to exercise supplemental jurisdiction and not decide any of the FAA motions, which would render the entire practice a waste of time.
Has there been a problem of when cases have been dismissed without prejudice to get back into federal court?
There are sometimes limitations problems, which you can see both in the Green decision from the 8th Circuit and Anderson in the 6th Circuit. But I think the more important point is not even the cases that can't come back. It's the very waste of time and resources litigating whether to stay or dismiss when it's such a one-sided bargain. There are over 800 contested arbitration matters every single year. There is very little upside to saying in every one of those cases, whenever anyone disagrees about whether to stay or dismiss, the party should brief that question, the court should waste its resources deciding it, the losing party could take an appeal. Instead of just saying, as a categorical matter, let's follow what the statute actually says.
Well, you talk about what the statute actually says. It says stay the trial, and respondent makes a lot of that. So what is your response to that argument?
I think we have a few responses. The first is this is the trial that would happen if there isn't an arbitration. So it's staying the trial of the action. This is trying the case, staying the merits adjudication so that the parties can effectuate the arbitration agreement. The other thing I would say is that when my friends suggest that there won't be a trial because the case is subject to arbitration, that's inherently speculative. There are lots of examples where a court compels arbitration and the parties return to court, either because there's a delegation clause and it turns out the whole dispute isn't subject to arbitration. You can have the plaintiff not initiating the arbitration. You can have the defendant not paying the arbitration fees, which is what's happened.
You would have an easier case if it said stay the proceeding or stay the action. I mean, the statute is using the word trial. You want us to interpret it to be proceeding or action, but that's not exactly what it says.
Well, for what it's worth, the title, which is actually a part of what Congress inserted into the United States Code in 1947, does say stay of proceedings. So Congress has always understood this to be staying the proceedings, the merits adjudication. Now, I think the FAA, which is not known for being the world's most precisely drafted statute, I think still, though, Congress here could have used that language for a particular reason. If you stay the entire case, it's not clear the court would have jurisdiction, because remember, it's staying the case until the arbitration is over. It's not clear the court would have jurisdiction to entertain motions under the FAA that would facilitate the arbitration. So let's say the parties have trouble appointing an arbitrator. Could the court then lift the stay to decide that motion? It's not clear. But if Congress is simply saying stay the trial of the action, that's staying trying the action, staying the merits adjudication, that leaves the courts available to decide these other motions under the Federal Arbitration Act.
Would a district court under Baggaro, could it dismiss rather than stay a federal action or a motion to compel if it properly concludes that it does not have subject matter jurisdiction over the case? Non-diverse parties. And only involves state law. You can't stay in federal court anyway.
I want to make sure that I'm answering the question correctly, so please correct me if I'm not. You're dealing here with the situation under Section 3. So there's already pre-existing suit in federal court where there is federal jurisdiction. Now, if a court concludes that there never should be any case in federal court, the underlying case on the merits is a state law dispute between non-diverse parties, the court would dismiss, it wouldn't compel arbitration, it has no jurisdiction to do anything. But if the court has jurisdiction at the outset, then Section 3 says this is the proper remedy for enforcing the parties' arbitration agreement. Do the stay. Once arbitration has been had in accordance with the agreement, then the court would have the option to exercise supplemental jurisdiction and decide the case going forward under the post-arbitration motions, or it could dismiss and say go to state court and force the arbitration award in some other venue.
Thank you.
I think just, I hate to belabor it. My friends just say, I think one of their stronger arguments is they try to suggest that there's inherent authority for a court to decide what to do when you have an arbitration agreement. I think that fails for multiple reasons. It first fails in its premise, because there is no inherent authority of a kind that this court has recognized as being the sort of timeless power that courts have in order to function as courts. This is effectively a substantive rule of decision. It's saying this is the procedure that a court should apply in deciding how to process an arbitration motion and enforce it in court. Even if there were some inherent authority, it's obviously been overridden by what we consider to be the fairly unambiguous language of the statute. Just one last point to Justice Jackson's question at the outset. My friends did suggest in their brief in opposition that trial really just meant trial, as in like the fact-finding event. It didn't state anything else. That, of course, is absolutely incompatible with the entire purpose of the Federal Arbitration Act. That would say that courts could actually entertain motions to dismiss, summary judgment motions. You could have court-based discovery. You could have everything as long as the court at the very last minute stops before impaneling a jury. We don't think that's a plausible reading of the Act.
Mr. Geis, I got one.
Go ahead.
I got one for you. On the inherent power point, and I take your point about the trial. I mean, I never filed a complaint where I didn't want a trial, and that was the whole reason why I filed the complaint. But on the inherent power, what about the district court's authority to dismiss a case for abusive litigation tactics, for example? Does this prevent that?
Absolutely not. So all Section 3 does is say, if the operative fact is, I found that any issue in the case is subject to arbitration, what do I do? That doesn't preclude the court's ability to access any other source of federal law that would let it do anything else in the case.
Very good. Thank you.
Your friend makes the point that the Arbitration Act is designed to prevent wasteful litigation, among other things. Why isn't it wasteful to maintain the case on the court docket if, for example, all claims are subject to arbitration?
I don't think it's wasteful for multiple reasons, including, first and foremost, it's very little waste at all. It's just an inactive case. The court can have a status report. It can be a sentence long. The case is still pending in arbitration. The stay should remain in effect. It's hard to imagine what kind of burden that would impose. And it saves waste in multiple ways. The first is that if the arbitration does fail, then the parties are coming back to the same court, filing a new complaint. They're doing new service, new case-initiating documents. They're spending a lot more of the court's time. It also would invite the court, again, as I said at the outset, to decide in each case, on a case-by-case basis, should I stay or dismiss. That is an enormous and wasteful use of the court's time that will overwhelm whatever minor savings a district court might have in not having to read a status report every so often. And the final point I'd raise is that it would also avoid the premature appeals. If you dismiss, if a court dismisses, that activates unintended finality. At that point, the case is final. The party has a right to take an appeal. They can challenge the arbitrability determination. That's inconsistent with what Congress wrote specifically in Section 16, and it would invite and breed even more litigation, as this court in Bissonnette just reminded that we shouldn't be doing, while parties are stuck litigating arbitrability on appeal at the same time they're trying to arbitrate the merits in arbitration.
So what do most courts do when they have a case like this where, they don't want to do anything, but there it is, still has to be on my docket?
Most courts, they do one of two things. They either have a requirement for intermittent status reports. Sometimes it's every 3 months, sometimes it's every 6 months, just let us know when you're done. Other courts will move it to an active status. So it's still pending on the court's docket. There's still a stay, but then they don't even have to worry about it at all. They just leave it to the parties to let them know once they're finished with the arbitration.
What's the worst thing that could happen from this?
The worst thing that would happen, I think, would be the court affirming. But the second worst thing would be, I think, if this were a national rule, it's going to consume an unbelievable amount of time and resources. And what it means is, as we've seen in the 4 circuits, I mean, if you look at the dozens and dozens and dozens of reported district court decisions with parties fighting, should we stay or should we dismiss? Where the upside of a dismissal is there's an immediate appeal that shouldn't happen yet. And the court is inviting potential problems in the future when parties come back and it turns out the arbitration fails for any number of reasons. And then they're litigating potentially limitations questions, possible tolling issues. It just creates an enormous problem out of a statute that's designed to eliminate problems. A simple stay, it's categorical, it's simple, go to arbitrate, let us know when you're done. In the meantime, it is imposing effectively no burden on anyone.
Counsel,
What would your argument look like if there were no Section 16, so neither party had the right to an interlocutory appeal?
I think we'd have one fewer arrow in our quiver, but I think our argument would otherwise be identical. I think Section 16 makes it our job a lot easier because this court does read sections in context. And when you have Section 16 and Congress saying specifically, you can take that immediate appeal if the court denies arbitration, but not if they grant arbitration, and subject to 1292B. So Congress was even thinking there could be exceptions. But if you dismiss, then you have an immediate appeal because the case is final. There's no second gateway with an appellate court deciding to accept a 1292B appeal. You don't have to meet any of those conditions. So I think it's really hard to understand how dismissal is consistent with Section 16. But even without that, we have our plain text reading, and we have all the other points that we've suggested are in our favor.
Counsel, what you've said that one of the reasons why stay is preferable to dismiss is that the court could then sort of continue to help out with certain administrative matters operating in the background when the arbitration is happening, like the appointment of an arbitrator under Section 5 or compelling witnesses under Section 7. As I read the respondents' response, they point to Badgerow and say that, well, there might need to be an independent jurisdictional basis for the court to continue to operate in that fashion. Is that how you read Badgerow with respect to those kinds of tasks?
Not at all. Badgerow involved a case where there was no litigation in federal court, there was an arbitration, and then there was a freestanding lawsuit filed simply to confirm or to vacate the arbitration award. In this case, there's pre-existing jurisdiction. You don't need more jurisdiction or extra jurisdiction. Once a court has power to decide the case, they can decide the case. And at that point, as this court said in Cortez Bird, once there is a suit and it's been stayed under Section 3, the court then has the power on the back end. Now, granted, it's in the court's discretion, it's supplemental jurisdiction at that point to decide whether to engage in any of those other motions. But we don't see any inconsistency with Badgerow, and in fact—
What about confirmation? Is that the same kind of thing? Would you think that the parties in a case like this, if it were stayed, could come back to this same court to seek confirmation of any award that was issued?
They absolutely could, and that's what Cortez Bird contemplates. Now, again, though, it's in the court's discretion, we admit. The court could say no.
Right.
I'm done with the case. Go have it confirmed somewhere else. And if the court did that and it was a proper exercise of the court's discretion, then we'd be out of luck. We'd have to go somewhere else to confirm the award. Which is also, by the way, why this is very different than Section 8. Section 8, aside from dealing only with maritime cases, is a specific instruction to retain jurisdiction all the way to the entry of the decree. So Congress is addressing a very different problem in a different way.
Suppose that on a Monday, a district court grants a motion to compel and sends the entire dispute to arbitration, and then the parties don't immediately ask for a stay. So on Tuesday morning, bright and early, the district court wants to clear up the docket, dismisses the case. What would happen there?
I think that the parties in reality would come back and say, actually, we would like a stay. It's a little too early to dismiss. If the party hasn't requested a stay, which is why what we did here I think is the best practice, when the other side says we move to compel, in the answer to the motion to compel, if you want to stay, you should say, and we would like a stay. That way you avoid that scenario. But technically, if the court has acted and the party hasn't requested a stay, then on its face, Section 3 hasn't yet applied, because it only applies if a party applies for a stay.
Thank you, counsel. Anything further? Thank you. Mr. Rosencrantz?
Thank you, Mr. Chief Justice, and may it please the court. When Congress directed courts to stay the trial of a case in deference to arbitration, it meant stop the litigation in court. It did not mean you must retain jurisdiction. It did not mean never dismiss. I get that modern lawyers often think of stays and dismissals as two completely distinct animals. But when Congress passed Section 3 100 years ago, Congress would not have drawn that stark a distinction. The drafters would have understood that a dismissal was one way to stay a litigation. When Congress intended that a court retain jurisdiction, it used those words in Section 8. Even if that is not the best understanding, this court should accept it as long as it's plausible. Courts generally have the discretion to dismiss cases without prejudice when no one is asking them to do anything here and now. and when another forum is actively adjudicating the case. If Congress wants to revoke that inherent power, it's got to do it clearly. And as Mr. Geiser said, Congress did nothing clearly in this statute. Congress did not issue such a clear direction. Congress does not even mention requiring ongoing jurisdiction. It does not even prohibit dismissing. Congress passed Section 3 to enforce contractual obligations to arbitrate and to avoid parallel litigation in court, not to encourage parallel litigation and reward plaintiffs who violate their contracts by suing in court. I welcome the court's questions.
Can you give another example of this continuing discretion when you have language similar to Section 3 that gives the part that makes it clear that a stay is to be granted?
Well, Your Honor, I quibble with the second half that it makes it clear that a stay is to be granted, but yes.
So what's unclear about it?
Well, so when Congress used the word stay back in 1925, it meant that it was requiring courts to stop the litigation, and it understood that courts could achieve it by either retaining jurisdiction over the case and putting it on ice, or by dismissing it without prejudice to come back if there's ever something for the court to do. In 1925, the word stay was just not categorically inconsistent with a dismissal. The lead definition of stay in Black's Law Dictionary at the time was stopping. The act of arresting what? Arrest could include a total discontinuance.
Counselor, putting aside that the title says stay of proceedings, and Black's Law Dictionary makes clear that that's different from dismissal. I'm going to put that aside. Can't put aside the language, which says stay until such arbitration has been had in accordance with the terms of the agreement. And so it's putting a limit. And it also says, providing that the applicant for the stay is not in default in proceeding with such when the application's made, the district court can't tell how long it's going to be, can't tell whether the party's going to go in default. I can't read dismissal into those two conditions. If they were going to permit dismissal, they would have put stay the action, period.
Understood,
You
Your
can
Honor.
reopen the action, or you can sue again if you don't have the arbitration concluded, or if the other party defaults or something. But that's not how they wrote it.
I understand, Your Honor. Let me just, I need to quibble with your first premise about Black's Law Dictionary. It supports us, not the other side. The very first definition is about stalling the proceeding. It's about stopping. But I'll answer the question about both the durational limitation and the proviso. They're two separate pieces. Until simply means how long the litigation has to stop. If the court has dismissed without prejudice, the durational language dictates when the case can return to court. The durational language was also necessary to establish that any non-arbitrable claims which cannot be dismissed may be litigated in court when the arbitration is over. But Section 3 is not a command to the court to retain jurisdiction for the duration of the arbitration. It does not say you must retain jurisdiction. When Congress wanted courts to retain jurisdiction, as it did in Section 8, it said retain jurisdiction, and it would not have needed to say retain jurisdiction in Section 8 if Section 3 already required the court to retain jurisdiction. As to the proviso that a stay applicant not be in default, that makes perfect sense on our reading also. If a plaintiff starts by filing an arbitration proceeding, that's the first thing. The defendant then refuses to arbitrate. The plaintiff can then file in court under Section 4. The proviso says when the defendant says, hold on, wait a minute, you need to arbitrate, The proviso says no, the defendant cannot force an arbitration because the defendant is in fault. Similarly, if the plaintiff begins in court and then the court dismisses without prejudice and the defendant then defaults, the proviso says that the plaintiff has a free pass from the arbitration.
Thank you.
Have there been any problems in the six circuits that have followed your friend's rule?
So yes, Your Honor, the problems in those circuits is that the courts are required to keep these cases on their dockets. And when you look at the differential costs to the district courts itself as opposed to the parties, this is, if you nationalize this is death by tens of thousands of cuts. You can imagine the practice articles that are going to emerge after this court issues exactly what Justice Thomas said in his very first question. Never ever file an arbitration first. Start in court, preferably in federal court, because when you're there, the court will be a helicopter parent for as long as you want it. Don't worry if there's zero basis for you to even resist arbitration.
Well, but what's the big...
guess I was just going to say, well, I guess the flip side of that is it's a much greater burden if the case isn't there and something arises where you need to go to court. You kind of have to start all over.
So, Your Honor, two observations about that. First is the burden on the district court and just having the case sitting there. There are 100,000 arbitrations a year. Mr. Geiser refers to only 800 of them that ever come back to court because they are contested. Once all of these stays are sitting in court, the court has to manage them. It has to report on them. It has to hold status conferences, possibly for years. And think about it from the perspective of these district courts. I know it's easy to say, what's the big deal, just hold a status conference. But there are courts that are in dire circumstances. They are overwhelmed. They are in emergency.
Is there a rule that the district court has to hold the status conference? I was not aware of that.
No, there's not a rule that a district court has to.
So they could just ask for a one-line report.
The court does not have to hold in-person status conferences. That is correct. But simply having to keep track of all of these cases, in some federal courts, there's no such thing as administrative closure. The court is constantly documenting and asking, wait a minute, is this case still alive?
Well, I may not be familiar with the practice, but why can't you just constantly monitoring it? Why don't you tell the parties if you need to get back or when something happens in the arbitration, let us know?
Well, Your Honor, it is the responsibility of the district court to know what's on its docket and not to keep cases on the docket that are not active. It's not supposed to be keeping cases that, for example, have settled and no one's told the court, or where the parties go to a different court for confirmation, which is perfect.
Presumably, Mr. Rosenkranz, the district court will just keep a list of cases now in arbitration, and that list will exist in some file someplace, and nobody will do anything with it, except if there's a problem.
Well, the district court still has to keep a list. That is still work, and it is more work than is necessary, because when you think about the flip side, to answer the second half of the Chief Justice's question, the flip side is, okay, so a party has to, if it ever needs further judicial intervention, the party has to file a new action. It's a streamlined process. It almost never happens. Courts almost never need to intervene to appoint an arbitrator or to compel a witness. Mr. Geiser points out a very, very tiny proportion of these arbitrations are even ever contested, and they may not even be contested in the same court. So it is needless.
But don't parties often seek confirmation of arbitration awards?
No, Your Honor. It's very rare. If the party on the other side is going to pay the judgment, for example, or if the defendant has won, no one really seeks confirmation.
Well, sure, if the defendant has won, but let's say we have a situation in which a plaintiff who originally brought this case in court because they thought it was the kind of thing that should be litigated in court, lost the motion for arbitrability, so it's now sent off to an arbitrator, and then Miracle of miracles, they win on the arbitration. My question is, isn't that a situation in which a plaintiff could at least come back to the district court if it had been stayed and ask for confirmation?
Hypothetically could, yes. It's very rare.
But if the case is dismissed, they would have to actually file a new action with the fee and everything else to open up that case, to which they, by the way, thought should have been in court to begin with, because in my hypothetical, that's where they brought it originally. Why isn't that more burdensome for the overall system than to just allow the district court to put this on a list somewhere, and if the plaintiff wins, be able to entertain a motion for confirmation?
Well, so two answers, Your Honor. The first is, as I was saying earlier, yes, hypothetically, the plaintiff in that situation could seek confirmation. It is very rare because defendants almost never challenge the judgment in the first place. So no one ever seeks confirmation. The case is sitting there without any need ever to come back to the district court. The second answer is filing a new action. It sounds like it's such a big deal, but there's a stream.
Like we paid, the plaintiff says, I paid on day one because I brought this in court and it was whatever the filing fee is. My case got shunted to arbitration. I win, and now you're saying I have to pay another $500
Sure. Sure. And then the flip side is there is a tax on the parties who are sitting in arbitration and also have to report to the district court. What the court would basically be saying to those parties is, sure, you have a right to arbitration, but you've got to report to the district court. Sometimes you have to negotiate with the other side on what that report contains. You've got to quibble over who's in default and why this is taking so long. And so that's hundreds of dollars of taxes on both parties for a case that doesn't need to sit in.
I'm sorry, Jim, your turn. You're saying that it's more trouble to let the thing just sit there than to file a new action. Just sitting there, but they've got to keep track of it and whatever, and saying the alternative is file a new lawsuit. It seems to me that the alternative would be a lot more burdensome than just sitting there.
It could be, but it may not necessarily be if there are constant and repeated reports. But we're not basing our argument on cost. We're basing our argument on the language of the statute. And a century ago, lawyers...
And just before you get back to the language, I mean, mightn't the statute of limitations have run if you have to file a new action, but the statute of limitations has run in the meantime? There's no tolling of the statute of limitations in the circumstance that you're talking about, is there?
There can be in some jurisdictions, but there's an easy solution to that. If a party wants to oppose a stay on the ground that there is a statute of limitations problem, they just raise that as a basis for the district court to deny dismissal. And the district court can consider that, or it can condition
But that's
dismissal.
just beginning to sound very complicated. It's like sometimes I should dismiss, sometimes I shouldn't dismiss. I have to go figure out what the statute of limitations consequences are.
Your Honor, look at the papers before the district court on this case when the parties were fighting about or arguing about stay versus dismissal. It was 3 paragraphs in their response brief in response to our motion to dismiss, and 2 paragraphs in our response brief. I'll give you the page numbers. It's 97 to 98 in their response brief and 103 to 104. It's not that complicated. But petitioners are trying to cram a lot of meaning into the word stay. They say it means stop the litigation and continue to exercise jurisdiction and don't dismiss, regardless of how unlikely it is that anyone is ever going to come back to court. The word stay does not carry all of that meaning. When Congress wanted to communicate wanted to communicate that the court must retain jurisdiction, that's what it said. It said retain jurisdiction, which is what it said in Section 8. I would also underscore there's another reason to read the statute our way. Section 4, a plaintiff can bring an action in the first instance, as I was saying earlier, under Section 4. seeking an order directing the court to compel arbitration when the defendant has refused to engage in arbitration. But Congress never said that the court has to retain jurisdiction in that circumstance, and the norm in that circumstance is that the district court dismisses after ordering arbitration because that's the only thing it's been asked to do. Now, if it was so important for Congress to make sure that parties never appeal a dismissal, never appeal an order to arbitrate while the arbitration is going on, if it's so important to Congress that federal courts retain jurisdiction while an arbitration is going on, it would have applied the same rule to Section 4, but it didn't. I was saying earlier that even if the court thinks that petitioner's reading is better, they cannot avoid the language of the statute or the ambiguity. They cannot avoid the result that we're arguing if the statute is ambiguous. Any doubt has to be resolved in favor of maintaining the district court's traditional discretion to dismiss cases when appropriate and preserving the backdrop common law in which courts routinely dismissed in deference to arbitration. When parties have nothing that they want the court to do here and now, a court has the power to dismiss without prejudice, but to dismiss in the interest of controlling its own docket and maximizing efficiencies for the court and all of the parties. Courts also routinely dismiss without prejudice when the parties are litigating a case before another forum. For example, when an agency is considering an important issue or a foreign court. The rules are especially salient in the arbitration context because, as I was saying earlier, the overwhelming likelihood is that this case is never coming back to any court, and certainly not, or potentially not even to this court. I'll give you an example. If parties settle a lawsuit—
How is that argument consistent with the language that Justice Sotomayor puts forward? I mean, I understand your point about the overwhelming likelihood is that it's not coming back, but the statute says stay until, so at least Congress thought that it could come back, right?
Congress certainly thought that there are circumstances in which a case could come back to the court, for sure.
Right. So doesn't that undermine your argument that we have to read this as though with an understanding that it's never coming back?
No, Your Honor, not with the understanding that it's never coming back, but preserving the district court's discretion to say, look, if you have something that you want to come back to me with, come back to me. But the answer to your question, Your Honor, is that until still works under our reading, because as I was saying earlier, until simply indicates how long the litigation has to stop for, and the party can come back to the court.
Yes, I understand. Thank you.
I thought until goes to the verb stay. Stay until.
Right, and if you read the word stop, the word stay to mean stop, which could entail a dismissal, you have to stop it until the arbitration is completed. And at that point, the court no longer has to stop it. So when it was dismissed without prejudice, the party can come back to the court and the stay provision no longer applies. And let me just say one last thing, which is that this court should also read Section 3 in light of the problem that Congress was trying to solve with Section 3. It was the problem that too many courts were not honoring arbitration obligations and were not stopping the litigation when parties violated their arbitration agreements and brought their claims in court. There's no reason to believe that Congress wanted to address that problem by requiring courts to hold on to lawsuits unnecessarily, much less by requiring courts to hold on to them in order to reward plaintiffs like petitioners who violated their contractual obligations to go to arbitration instead of court. Just to sum up, this court is not deciding, and we're not asking the court to decide what stay means in all contexts and for all time. And all I'm saying here is that context matters. In the context of the Federal Arbitration Act passed a century ago, Congress was trying to solve a specific problem that courts were refusing to stop litigation in deference to arbitration. Our reading comports with the leading dictionary definitions and the cases that routinely dismissed. At the time, the common way to stop litigations was through discontinuance or dismissal, and Congress said retain jurisdiction when that's what it meant. All of this supports our position that stay means stop under Section 3. But at a minimum, the alternative reading is not as clear as my friend on the other side suggests, and it's not enough to overcome both the prevailing common law practice and the court's inherent power to dismiss cases with prejudice when another forum is addressing the dispute and none of the parties have anything for the court to do here and now.
On your point about Congress's overall objective, if it's dismissed rather than stayed, then that opens up the interlocutory appellate right. Would Congress have wanted that?
So, Your Honor, a couple of things to say about that. First, it is simply not true that the FAA generally postpones appellate review of orders to arbitrate until after the arbitration. I was giving the example of a case that begins in arbitration and the defendant refuses to arbitrate. What happens next? There is an action under Section 4, and that is an action that asks for only one thing, which is to compel arbitration. When that order is granted, the case is routinely dismissed and the appeal will follow. So it is simply not true that there's a grand congressional design not to allow appeals of orders granting arbitration. In any event, this court has already rejected petitioner's argument about the effect of Section 16. B in Greentree. That case explains, obviously, where Congress was anticipating that a court would stay, but it was not saying that the court has to stay. The court still has the discretion. Nothing in that section bars an appeal of a final order, which is what a dismissal is. And the last thing I'd say about that is that I know one reads a statute as a whole, but we have to bear in mind that Congress used the phrase stay the trial of the action. It wrote it in 1925. Section 16 was passed 60 years later. It is highly unlikely that Congress intended Section 16 to affect the interpretation of Section 3. And I would also say that Congress acknowledged in its Senate summary that it was anticipating that there would be dismissals followed by appeals. The dismissals would be final, and that would trigger an appeal.
Thank you, counsel. Thank you. Rebuttal, Mr. Geiser?
I'll be brief. My friend says that we're cramming a lot of meaning into the word stay. We're just saying that stay means stay. At the time in 1925, if you look to Black's Law Dictionary, stay was stay of proceedings, which is what this is, was defined as a temporary suspension of the case. It's exactly what Section 3 is doing. My friend says there are other dictionaries that say total discontinuance. He's referring to the Dictionary of American and English Law. That's a second definition of stay. The first definition was a temporary suspension. Again, exactly what stay always means. I think if this court tried to stay a lower court order and the lower court turned around and dismissed the case, I think the court would be fairly surprised. It's just not a consistent understanding of what stay means. Justice Sotomayor is exactly right that the definition of stay meaning suddenly dismiss is inconsistent with the surrounding clauses. Justice Jackson is also correct that it's inconsistent with the proviso at the very end of Section 3 that shows that Congress itself contemplated that cases could come back to court because arbitrations do sometimes fail. Sometimes parties are in default. My friend pointed to the difference between Section 4 and Section 3 and said that you can take an immediate appeal when a Section 4 petition is granted and dismissed. That's because there's no alternative. When else can you take that appeal? You'd have to craft an entire new appellate scheme. When would you take the appeal from 30 days from what event? Where would you file the notice of appeal? If there's no longer a court case, I don't know where you go to the district court to file the notice of appeal. Congress looked at that and said, no statute pursues its purpose at all costs. We can't have unreviewable district court orders compelling arbitration. So in that context where there isn't a pre-existing freestanding suit, we will allow the immediate appeal. In terms of wasting time, it is inherently speculative to say some cases are unlikely to come back, some cases are likely to come back. Will there be a tolling problem? Will there not be a tolling problem? Those are exactly the kind of issues that are pointless for courts and parties to debate. It's much easier to say, let's just stay it. It's exactly correct. As multiple members of the court has recognized, you maintain a list. This court will maintain cases that are contemplating settlement on its petition stage docket. I don't believe it's overwhelming the court to do that. It's not overwhelming district courts who can truly say, just let us know whenever the arbitration is finished. If you do look at the briefing in this case, I think it probably consumed a good 50 or 100 status worth of time of status reports that we could have filed instead of having to debate this at the district court and then debate it on appeal. Unless the court has further questions.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
Thank you.